Good evening, distinguished guests, ladies and gentlemen. I begin tonight's event by acknowledging the traditional owners of the land on which we're gathered, the Gadigal people of the Eora Nation, and I pay my respects to their elders past and present. I'd also like to extend a special welcome to any Aboriginal or Torres Strait Islanders who are in the audience today. My name is Andrew Lynch and I'm the Dean of the Faculty of Law and Justice at the University of New South Wales. Welcome to the inaugural Margaret Stone Lecture, co-hosted by the School of Private and Commercial Law at UNSW and Herbert Smith Freehills. The lecture honours the life and contribution to the law of the late Honourable Margaret Stone AO. I anticipate that many of you here tonight knew Margaret personally, possibly as colleagues when she worked as an academic, a practitioner, a judge and statutory office holder. Or perhaps you knew her most as a friend, mentor, or indeed knew and loved her as wife, mother and grandmother. I did not personally have the pleasure of ever meeting Margaret Stone and know her only through her work and also the affectionate reminiscences and admiration I've heard so often from my colleagues and many others over the years. With the abundance of those tributes, I feel I have some little knowledge, but I wish I had more. The essential outline of Margaret Stone's career is readily traced. From Holy Cross School in Sydney, she worked her way through a degree in English and philosophy at the University of Sydney. Then, with a young family, she tackled the law, graduating with honours and the Supreme Court Prize at the ANU in the mid-1970s, and later a Master of Laws at Yale. These degrees and her 15 years as an academic at UNSW were the intellectual foundation of her career. Although Margaret left academia in the late 1980s to take up private practice at the then Freehill, Hollingdale and Page, she maintained her connection with UNSW as an adjunct professor, teaching classes in commercial equity and land transactions. At Freehills, she rose from consultant to partner, serving over a decade. Just as at the university, Margaret's personal warmth and disciplined intellect ensured her success and earned her the admiration and affection of colleagues, especially the many for whom she was a mentor. She was generous with her time and understanding. She specialised in the areas of commercial property, infrastructure and development, commercial finance and taxation. Margaret accepted appointment to the Federal Court in 2000, where she served with great distinction until the compulsory retirement age. In the decade following, she served firstly as an independent reviewer of ASIO's adverse security assessments, seeking to resolve the problem of the long detention of some refugees, before accepting appointment as Australia's Inspector General of Intelligence in 2015. As an acknowledgement of her distinguished service to public administration, particularly to national security, to the judiciary, and to legal education, Margaret was honoured by the Australian Government in being appointed an Officer of the Order of Australia in 2019. She was also a Foundation Fellow of the Australian Academy of Law. In 2022, she received a Doctor of Laws honoris causa from UNSW, the university's highest honour, and exceptionally, and sadly in her case, awarded posthumously due to the pandemic having prevented an earlier conferral. Margaret Stone devoted her life to the law, with her journey from law school through private practice to the pinnacle of the legal profession, the bench. For Margaret, the rule of law was the guiding principle throughout her career, and she maintained a firm belief in its importance to the enjoyment and protections offered by a peaceful society. The establishment of this lecture has been with the support and encouragement of Justice Stone's family, and I extend a warm welcome to Margaret's husband, Professor Jonathan Stone, and her daughters, Professor Adrian Stone and Dr. Emily Stone, who join us this evening, and also recognise Margaret's youngest daughter, Elizabeth, who couldn't be with us tonight as she commences as headmistress of Winchester College in the United Kingdom just next week. I wish to thank the Chief Justice of New South Wales, the Honourable Andrew Bell, for generously agreeing to host this lecture in the Banco Court of the Supreme Court of New South Wales. And I also thank our friends at Herbert Smith Freehills, who have worked with my UNSW colleagues, principally Associate Professor Scott Donald, Professor Simone Degerling and Rachel Seymour, to make this event possible. And in particular, I acknowledge the enthusiasm for the creation of the lecture and substantial support from Danielle Kelly and Michael Vrysakis of HSF. Now it's my pleasure to welcome the Honourable Justice Michelle Gordon, AC, to present the inaugural Margaret Stone Lecture. Justice Gordon was appointed to the High Court of Australia in June of 2015, and at the time of her appointment was a judge of the Federal Court, like Justice Stone, to which she had been appointed in 2007. Her Honour graduated in law from the University of Western Australia and was admitted to practice in that state in 1987 and joined the Victorian Bar in 1992. She was appointed Senior Counsel in 2003 and practiced in state and federal courts, principally in commercial, equity, taxation and general civil matters. She was appointed a Professorial Fellow of the Melbourne Law School in July 2015, where she's taught for many years. Please join with me in welcoming the Honourable Justice Michelle Gordon, AC.
The First Peoples of this country continue to practice their values, languages, beliefs and knowledge on the land and waters as they have done so for millennia. I pay my respects to the traditional owners, custodians and elders of all lands in Australia, but particularly today to those peoples and their elders of the land on which we meet, and also to those who are here this evening. That acknowledgement and paying of respect is not a matter of form. It reminds us that our First Peoples are the oldest living, continuous cultures on this earth. In 2000, on her swearing in as a judge of the Federal Court of Australia, the Honourable Justice Margaret Stone wisely and prophetically said, "The challenge for a judge is both to heed criticism, to profit from it, and yet not be overwhelmed by it, to maintain one's integrity, but to benefit from the criticism and the unhelpful comments of others, probably even the unhelpful ones. That seems to me to be the essence of the task. I have some confidence that everything yields to hard work, and I can undertake to put in that hard work. For the rest, I rely on the guidance of the whole of the legal profession, coupled with my own natural inclination to ignore it at times." My first interactions with Margaret were from the other side of the bar table not long after that swearing in. As counsel, she sought my guidance, she interrogated that guidance, and she certainly ignored aspects of it. And in doing so, Margaret immediately revealed her formidable intellect, her extraordinary capacity for hard work, and her interest in and commitment to identifying and interrogating the underlying principles in issue in any given dispute. Margaret's approach to the law was one of principle and not nomenclature. It was an approach informed and revealed by values and characterised by absolute intellectual rigour and wise judgment. In subsequent years, I became the beneficiary of Margaret's guidance as a colleague, companion and confidant. Guidance, not advice, but guidance that you ignored at your peril. It is an absolute honour and privilege to be asked to deliver the inaugural Margaret Stone Lecture in the presence of her family, her friends and her colleagues. Margaret's appointment to the Federal Court was the third chapter in a long and distinguished life. The reference to a chapter is in fact a misnomer, because as you heard, many aspects of Margaret's extraordinary life were constant. What might be described as the first chapter, as an outstanding legal scholar and academic, informed her life. It physically overlapped with her time as a solicitor and then partner in Freehills, Hollingdale and Page. It was on public display as a judge of the Federal Court, and it was at the forefront of what Margaret did after retirement from the court, again as an academic and in her roles including overseeing Australia's intelligence community. On 16th March 2021 at her home here in Sydney, Margaret gave an interview as part of the Inspector General of Intelligence and Security Oral History Project. It would be one of her last, as she passed away less than 6 months later. In that interview, Margaret reflected on her life and the law. She spoke of the events that saw her enter the lecture theatres at law school with daughters in hand, and one of her first encounters with her courses. Margaret observed that one of the subjects that fascinated her was property law because of its history and development and how it challenges how we think about law, how property law challenges conceptions. She described it as beautiful. That That description caused me to smile. On one hand, because it was such a Margaret response, intellectual and visceral. And on the other hand, because I just read another legal scholar observe that in the life of law there's never been a settled understanding of the nature of property law that has commanded widespread support over the long term, and perhaps there never will be. This lecture, in honouring Margaret, seeks to identify and explain why Margaret saw, conceived of property law as beautiful, and how her conception of that beauty informed not only her legal thinking and judicial method, but so more and so many more. One need only glance at Margaret Stone's academic scholarship to appreciate that her fascination with property law, particularly real property law, continued well beyond law school. It's evidenced in particular by her part authorship of several editions of Sackville and Neave Australian Property Law, the prescribed test most of us had at law school, and her joint authorship of Torrens Title. In her academic work, both teaching and writing, Margaret placed great importance on situating law in its historical context. Both her property law texts traverse the history of land law in great detail. But that bland description, in great detail, may hide, for all whose memory of their studies of land law has faded, the depth and breadth of Margaret's examination of that history, and will almost certainly hide the importance she attached to considering it. Equally importantly, saying that she treated history as very important doesn't tell you why she considered it so or what she took from it. As I will later explain, Margaret's judicial work, like her academic work, showed that she saw the law as being founded in, formed by, and reflective of principles and values that can be identified and tested only by understanding what's gone before. The law for Margaret was not to be understood, and I would say cannot be understood, by reference only to labels or boxes. Labels or boxes may or may not be useful, shorthand methods of describing particular forms of legal argument, but they provide no adequate basis for identifying and in truth interrogating the principles or values that underpin them. And it is these very principles and values that underpin the past development of the law which inform its future development and application. Because history played the part it did in Margaret Stone's academic work and informed and explained so much of her later judicial method, let me try to offer a very short potted history of the history she treated as informing her work in property law. Of course, that history covers many centuries, but it's the depth and breadth of that history that both reveals and underpins what I later say about Margaret's overall understanding of and approach to the law as depending upon identifying the relevant underlying principles and values. Throughout history and across different societies, there have been all kinds of variations of property systems. The traditional relationships of Indigenous peoples to land, the landed hierarchy of a feudal system, the command structure of a socialist state, private systems of ownership where much is left to the competence of individuals to make decisions over the allocation of property resources. The choice of property system and how it has been refined warrants consideration, not only because the distribution of property rights has a profound impact on economic, cultural and social dynamics, but also, I think, because the converse is equally true. The development of property law was driven by and reflects developments in society, its activities and organisation. In this way, the law of property can be seen as a tapestry that has been interwoven with and which on closer inspection reveals the threads of societal change. A tapestry which is forever added to as the concept of property and the rights to which it gives rise evolve in response to economic, social, legal and technological changes. As I said, throughout history, societies have had arrangements for sharing and allocating resources between persons, the state and other actors, and they have had arrangements for delineating legal rights in relation to those resources. Sir William Blackstone in 1773, in the opening pages of his book of the Rights of Things, said, "There's nothing which so generally strikes the imagination and engages the affections of mankind as the right of property, or that sole and despotic dominion which one man claims and exercises over the external things of the world, in total exclusion of the right of any other individual in the universe." Yet there are very few that will give themselves the trouble to consider the origin and foundation of this right. To fail to give ourselves the trouble to consider the origin and foundation of rights of property is a folly. To quote Margaret, it is only with a full knowledge of the historical facts and their consequences that the aims, hopes and possible principles underlying title may be appreciated. So a consideration of history is where we should start. What follows in the time available are just some of the threads of the tapestry of that history to illustrate the beauty Margaret saw in property law, its dynamism and its inescapable development, not unbounded by the past and not untethered from principles or values. At the end of the 19th century, it was said of English land law that it was of mixed origin. That was an understatement. The elements in the mixture included the customs of the early Teutonic invaders, the effect of conquest and settlement of the land on a large scale, the gradual and what may be called the natural growth of feudal ideas, the effect of the Norman conquest in developing these ideas into a system of law, and of course the subsequent influence of Roman and canon law. These are all elements of which account must be taken in tracing the development of the law of property, and all of them are elements that not only informed our historical understanding of whether and how real property could or should be applied in new and emerging areas, but that continue today to inform an understanding of developments in property law and the principles and values that the law codifies and protects more generally. In the time available, can I just briefly identify 4 changes in the development of property law in England to illustrate my point. First, the feudal system of 1066. Second, the statute of quia emptres of 1290. Third, the statute of uses of 1596. And finally, the development of registration of title. And I'll then address 2 fundamental changes in Australia before turning to consider that history and how it informed Margaret's conception of property law and her approach to legal analysis and what we all learn from it. Can I turn then quickly to the feudal system? For any common law jurisdiction where principles of property law have come from or have been influenced by English common law, a tale of real property law cannot be told without an appreciation of the doctrine of tenure developed by the feudal system. Introduced in 1066 by William the Conqueror following the Norman conquest, the feudal system rested upon the premise that all land was held mediately or immediately from the king, and that service was due directly to him. In reward for loyalty, the king granted feuds, allotments of land to his followers, who in turn made grants to their tenants. The relationship of feudal lord and tenant thus entered into was one of mutual obligation. A measure of security was assured the tenant by having his title warranted by the lord. And the lord was bound to provide lands of equal value if the tenant was ejected by reason of another person or tenant showing superior title. Under this system, land was the subject of tenure, not ownership, and thus we had the maxim, no land without a lord. But as no land was owned by a subject under this system, it became more accurate to refer to a person holding an estate in land or as being a tenant of land, rather than being the owner. The estates were of various duration and divided into classes. Estates of freehold and estates of not freehold, generally leasehold. Freehold estates included life estates, the fee tail and the fee simple, and while the fee simple may have been close to absolute ownership, the king remained paramount of all land within the realm. At that time, though, tenants could really only alienate estates in fee simple by obtaining the consent of the lord or by the process of substitution or subinfeudation. Both systems presented difficulties for the superior lords in allocating resources. As Sir Frederick Pollock explained, these under-tenures were constantly multiplying, and not only titles became complicated, but the interests of superior lords were gravely affected. The lord's right to the services of the tenant were in themselves unchanged by any subinfeudation, but his chance of getting them practically depended on the punctuality of the under-tenants, against whom he had no personal rights. The profits coming to him were also diminished, and for many years the great lords thought themselves ill-used in the matter. So the Statute of Quia Emptres of 1290 sought to remedy these issues. Also called the Third Statute of Westminster, it forbade subinfeudation It prevented tenants from disposing of land to subtenants who felt dependent on and accountable only to the mean lord from whom they immediately held the land. Pollock said the statute was accepted with satisfaction by all. Why? He explained it dealt a heavy blow to the consistency and elegance of the feudal theory, but made the conditions of land tenure far more simple. It was the first approximation of feudal tenancy to the modern conception of full ownership. The statute enabled the fee simple tenant to deal with his land as property without consulting his lord, and in this respect, it was a great economical advance. And the advances were significant, legally, socially, economically. But on the other hand, there were long-term consequences. The profits of feudalism increasingly became the profits of Crown, and by Tudor times, the incidence of mean lords had declined. But the skills of avoiding feudal incidents had increased. The result, the Statute of Uses of 1536. It was described by Sir William Holdsworth as perhaps the most important addition that the legislature has ever made to our private law. Others took a less favourable view. Sir Frederick Maitland said it's not a mere statute of uselessness, but a statute of abuses. Whatever you describe it, the import of the reform can't be doubted. Before the Statute of Uses, a landowner could convey land to a trustee for the use of a beneficiary, who might the landowner himself, or a third party. As one legal academic explained, the principal reason for the development of uses lay in the fact that feudal burdens and disabilities related only to the holders of legal title, while conversely the rights under a use could not be forfeited, and nor could they be charged with other feudal incidents. Thus, during the period when the feudal system was at its height, landlords could avoid many feudal incidents that were owed at common law by vesting another with legal title, while reserving the use to themselves. In short, it became a measure of tax avoidance, and by the reign of King Henry VIII, the Crown was encountering financial difficulties. So what the Statute of Uses did was to vest the legal estate of the trust property in the beneficiary, thereby rendering the beneficiary liable to the payment of feudal incidents. The statute saw reimposition of the feudal incidents, but it also became the means by which legal title could be transferred by document alone, thus providing for secrecy of title. In itself, that became a problem, and it was a problem sought to be avoided by the enactment later in the same year of the Statute of Enrolments. It was described by Sir Francis Bacon as the proviso to the Statute of Uses, and it was intended to alleviate the secrecy permitted by the Statute of Uses by providing a register of conveyances. That system relied upon property having been granted by the Crown and transferred by a particular document, referred to as a deed on conveyance, on each transfer of title. The title deeds, therefore, together comprised the chain of title, and only where the transferor had the right and capacity to transfer the relevant interest would the transfer acquire a legal interest. The effectiveness of such a system was thus dependent upon the execution and preservation of original valid instruments, and consequently the system had several defects: fraud, forgery, error, practical complexity, and the like. Following that Statute of Enrolments, no further system of registration developed for about 2 centuries. In the early 1700s, a new system of registration of deeds was enacted. The expansion of that system by registration was the subject of parliamentary debate throughout the mid to late 1700s, and it wasn't until February 28, when a Royal Commission was appointed to examine the law of property, that things began to move. The second report of that Royal Commission in June 1830 concerned the subject of a general registry of deeds and instruments relating to land. The question of registration of title wasn't directly dealt with in the report, and although the bill subsequently introduced met opposition, the report laid a foundation for a system of registration, and interestingly took its structure, its foundations, from another area of property law, stocks and the Register of Stocks. Those 4 fundamental changes, as I've said, I've dealt with briefly. But Australia is, of course, distinct, but it shares the same reliance on history, principles and values. Two developments in particular shaped and reflected the evolving legal, social and cultural landscape in this country. Can I just identify two? First, the introduction of the system of torrens title in Australia in the 1850s. Property law in the early days of the colony of South Australia was riddled with confusion, and in 1857 a bill was introduced into the South Australian Parliament which became the Real Property Act of South Australia of 1858. The preamble observed that the inhabitants of South Australia are subject to losses, heavy costs and much perplexity by reason that the laws relating to the transfer and encumbrance of freehold and other interest in land are complex, cumbrous and unsuited to the requirements of the inhabitants. The Act introduced torrens title, the system of title by registration that we all know is now used in all states. And as James Hogg acknowledged in his 1905 work, it didn't arise out of the blue. The torrens system was said to have been planted, or the germ of it, in the English jurisprudence by the publication in England of the report of the Royal Commission that I've just referred to. Any discussion of Australian property law would also be incomplete without reference to the second significant development 150 years later, the 1992 decision of the High Court in Mabo No. 2. As Justice Brennan said in that case, the common law of this country would perpetuate injustice if it were to continue to embrace the enlarged notion of terra nullius and to persist in characterising the Indigenous inhabitants of the Australian colonies as people too low in the social organisation to be acknowledged as possessing interests and rights in land. Moreover, to reject the theory that the Crown acquired absolute beneficial ownership of land is to bring the law into conformity with Australian history. The dispossession of the Indigenous inhabitants of Australia was not worked by a transfer of beneficial ownership when sovereignty was acquired by the Crown, but by the recurrent exercise of a paramount power to exclude the Indigenous inhabitants from their traditional lands as colonial settlement expanded and land was granted to the colonists. Dispossession is attributable not to a failure of native title to survive the acquisition of sovereignty, but to its subsequent extinction by a paramount power. It was an inhabited territory which became a settled colony. It was not a legal desert. Native title, though recognised by the common law, was not an institution of the common law and was not alienable by the common law. But the common law could, by reference to the traditional laws and customs of our Indigenous people, identify and protect their native rights and interests. Whether or how common law property notions intersect with native title is now working its way through the Australian legal system, and I say no more about it. If one reflects on that potted history of some 900 years or so, what immediately becomes self-evident is not only the evolving nature of property law, but how and why the law developed as it did. No development was untethered from the past, and no development was shorn of a need to consider and address broader societal issues or values. Each development is both a history lesson and a lesson in one of more of human endeavour, human advancement and thinking. Each of the developments that were affected were necessary to reflect changes in its society, its activities and its organisation. What then of the position now? While often considered a stable body of law with deep roots and developing slowly, as Professor Ernst Nortfeld has recently said, if this was ever true, it's not so anymore. Basic tenets exist, of course, and the development of new forms of property rights is often based on older forms. However, contemporary property law is a dynamic system that changes alongside technological, economic, financial, social and ecological changes to meet new needs, achieve more effective use of resources and conform with the dominant values in society. While property and property rights can seem to be nigh on universal phenomenon, deeply embedded in human history, ownership and property rights remain among the legal realities that I think are hardest to define. Few other legal concepts, if any, have caused such strong debate. Today, the word itself, property, remains ambiguous. There are, I think, at least two ways in which the word is used. First, a legal right of a particular kind, and second, the tangible or intangible thing which is the object of that right. It's with the former that I am presently concerned. Put broadly and loosely, a property right gives the holder power over or inspect the subject matter of the right. Often that power will amount to rights of exclusion, possession or occupation. But this description is altogether too short and compressed and belies much of the complexity that attends property law. Property rights can, for example, be tangible or intangible, corporal or incorporeal. The developments in the feudal system experienced as the dealing with tenures grew in complexity provide, I think, early evidence of how new forms of economic goods, tangible and intangible, develop as a result of financial and legal developments. As new subjects of property rights emerge, so too new rights with respect to those subjects emerge. And inevitably our thinking about property law is challenged. And even then, while relative consensus on a conception of property expressed in terms of rights might have emerged, that's not quelled the questions. What rights are properly called property rights? What kinds of subject matter can be the subject of property rights? And these questions have evoked many answers. As one legal scholar recently said, one difficulty with the entire enterprise of defining property may be the natural desire of the systemiser to unify different categories that have both similar and different characteristics. The more grand the theory and the more it attempts to encompass, the more likely it may be that the theory will be expressed at such a level of abstraction that is at best generally inutile and at worst productive of confusion and error. This is a view which Margaret would likely have agreed. It is a view which is wholly consistent with what she wrote more than 10 years before her appointment to the Federal Court about the High Court's recent decision then in Mashinsky and Dodds. There, as we know, the court held that the parties held their respective legal interests in land on trust after payment of joint debts incurred in improvement of the land to repay each of the contributions she or he had made, and as to the residue for them both in equal shares. In the article, Margaret wrote about the reification of legal concepts, which she explained as connoting an essentialist mode of inquiry, which assumes that judges must recognise interests in terms of their essential features. To this, Margaret wrote, "Law is a metaphysical, not a physical phenomenon, and legal concepts are tools which ought to work for us rather than impose burdens. When courts reify these concepts, they become enmeshed in nets of their own making and must perform Houdini-like feats to escape." The answer, Margaret urged, will be found not in the nomenclature adopted, but in an analysis of the respective merits of the parties to the litigation and any third parties in contemplation. She made, I think, a number of important and interconnected observations, posed essential questions, and then set out her approach. She observed that the statement that judges are free from logical compulsion to apply particular rules in particular ways does not imply that they are free from all restraint. She posed the question, the matter really comes down to the perennial problem of how, in the absence of a binding precedent, a judge arrives at and justifies their decision. What role do the precedents play if they do not determine the question in the instant case? Margaret pointed out that Julius Stone gave a convincing account of how and why precedents do not bind, do not logically compel a particular conclusion. She said he was neither so explicit nor so detailed, however, about the extent of their influence in the absence of this logical compulsion. Her answer? It is clear that though precedents may not compel, they still have a considerable role to play. A judge, she says, does not make their decision in a vacuum, and previous approaches to similar problems will combine with other factors too numerous to mention to restrict what she described as the leeways of choice. She observed how commentators have emphasised different aspects of the restraint which they are seeing affecting judges and have given varying weight to their influence on the development of the common law. She said Stone and Llewellyn have referred to steadying factors, Dworkin to principles, McCormick to coherence, Kober to fidelity, and Craigier to tradition. She concluded by observing that irrespective of emphasis, identification of these factors makes explicit a recognition that even judges consciously making law are not totally free from restraint. Her view? an instrumentalist approach that recognises that even where precedents do not bind, they clearly influence, and it allows a judge to take enlightened advantage of the wisdom of previous decisions. Underpinning and informing what Margaret said in rejecting reification and urging instead for an instrumentalist approach was her adherence to the need to root development of the law in principles and values discerned from what has gone before. As she pointed out, many scholars have grappled with how, absent binding precedent, a judge arrives at and justifies the decision reached in a novel case. All recognise that precedent has a role to play. All say that there are limits on the leeways of choice, though they differ in how they think those limits are best described. Her rejection of reification, the search for essential features as if describing a class of tangible objects, coupled with her references to an instrumentalist approach and law being a metaphysical, not physical concept, point firmly towards her looking back at the relevant history to discern what principles have been applied earlier and what values were given effect to in what was done earlier. What then is to be done in the novel case is to be determined in light of those principles and values, either by demonstrating consistency with them or by exploring why departure from or modification of those principles is warranted. None of that can be done without knowing how and why those principles and values developed and were applied in the past. That history sets the field of play. In the law of real property, it demands understanding what lies behind the law as it now stands, a history of intertwining threads spanning centuries. And in that field, as in all other fields of the law, identifying how and why particular principles and values have developed will in turn demand a broad and deep consideration of whether and how those particular principles and values would seem to emerge from previous cases in the particular area under consideration, and how they intersect with or are affected by principles and values which inform, of course, other aspects of the law. For my own part, I would add one additional, if obvious, point. The search for principle and for the values to which effect has been given cannot stop at the point of observing only that what was said in one or more earlier cases could be applied to the case at hand without substantial verbal modification. To stop at that point is, to use Margaret's words, reify the reasons for judgment in the earlier case. It is to treat what was said in a different kind of case as if it were a complete statement of the applicable principle in all kinds of cases, including the new and different case under consideration. It either assumes or asserts that the case at hand has the same essential characteristics as the case from which the quotation is taken. These ideas inform so much of what Margaret wrote. They lie at the heart of her writing about real property because she was at pains to point to the history which lies behind what we now understand to be the law of real property. And these ideas lie at the heart of what she wrote about Mashinsky and Dodds, then a novel case about property rights. By rejecting the notion that a principal law can be identified and described as if it were a tangible object, Margaret pointed to the cardinal importance, as I said, of recognising that law is a metaphysical, not a physical phenomenon. And because law is a metaphysical phenomenon, what I earlier referred to as labels and boxes cannot be treated as the end of legal analysis or as the premise for arguing about further development of legal principle. Attaching a label or putting a group of results into a single box may or may not be a useful way of describing what has been done, but the description is truncated and cannot be treated as if it were exhaustive. And the description of what has gone before will not without more, I think, tell the inquirer whether new facts and circumstances should or should not yield a generally similar legal result. Rather, as Margaret said, legal concepts are tools. They ought to work for us rather than impose burdens. They are tools to be developed and applied in ways which accord with values. By values, I do not mean the idiosyncratic values of the judge or the formless void of individual moral opinion, but the values that are identified as underpinning what has gone before. Legal concepts are tools to be applied and developed in ways that give effect to principle, in the sense that they take proper account of established principles and yield results that can be seen to be based in principles that are wider and deeper than simply A should win or B should lose. In a common law system, proper judicial method reflects these considerations. Novel issues cannot be resolved by reasoning only from a label or reasoning backwards from a desired result. The common law demands that they be resolved by identifying and justifying the principles that are to be applied. These ideas were captured by Sir Gerard Brennan when he said of the High Court, and I quote, "The court cannot refrain from determining matters within its jurisdiction, simply because a new rule must be devised for the purpose. To perform this function, the justices must master the existing authorities and from them elicit the underlying principle. In some cases, it's necessary to perceive, if not articulate, the community value which gives vitality to the law in question. Then, provided the value is consistent with enduring community values, the principle must be re-examined, and if need be, it must be restated in contemporary terms that can be integrated with other legal principles, and a new rule, appropriate to the case in hand and expressed to apply to the instant and future similar cases, is formulated. This work, though conceptual in nature, requires more than intellectual rigour. It requires the wisdom which each justice must bring to the task. Identifying principle, the relevant values, intellectual rigour coupled with wisdom, or some might describe judgment, has always been and remains critical to the judicial task. It's not easy. Throughout her career, Margaret Stone championed a pragmatic and principled approach to the law and the process of judging. She was at once alive to the leeways for choice presented by virtue of the dynamism of the law and its inescapable development, but also strongly adhered to the view that there was little that did not yield to hard work and principles, not nomenclature, informed by values, subjected to absolute intellectual rigour and wise judgment. That was the beauty Margaret saw in property law, the law more generally, and in life. And I hope that this lecture has done justice to some aspects of the beauty and rich tapestry of the life of the Honourable Margaret Therese Ackery Stone AO, a remarkable legal scholar, jurist, judicial philosopher and human. Thank you.
Good evening, Your Honour, Chief Justice, esteemed guests all. My name is Scott Donald and I'm an Associate Professor in the School of Private and Commercial Law. It's my pleasure and privilege to deliver the vote of thanks today. I'd like to start by acknowledging the ongoing custodians of the various lands on which we all work and pay respects to elders past and present. I also extend that respect to other Aboriginal and Torres Strait Islanders people present here today. We have much to be thankful for today on the occasion of this, the inaugural Margaret Stone Lecture. Thanks first to the Chief Justice for permitting us into this incursion into the Banco Court, thereby emphasising the interconnections between the judiciary, the academy and the profession generally. Margaret embodied all of those links and in so doing provided an example to us all. Thanks also to the partners of Herbert with Freehills, without whose enthusiasm for the project everything would have been so much harder. Thanks also to Margaret's family, a number of whom are here today. You were the foundation on which Margaret's work and her life relied. Thank you for sharing her with us, and thank you for allowing us to continue to benefit from her example. Now, thanks to her Honour, oh, she's over there. Thanks to Her Honour, Justice Michelle Gordon, for delivering the inaugural Margaret Stone Lecture. Judge, you reminded us of the beauty of property law, or at least property law in the right hands. You reminded us of the importance of historical context for the way in which the principles and values of the law impel its historical trajectory, and of the way in which the law influences and is influenced by the contemporary economic, social and cultural conditions. You took us on what you described as a potted history of many hundreds of years, to the doorstep of property theory as it's now understood. You reminded us of Margaret's observation that law is a metaphysical, not a physical phenomenon, and legal concepts are tools which ought to work for us rather than impose burdens. That instrumentalist approach equips us to deal with technologies and societal aspirations that evolve, jumping forward in fits and starts and in often unexpected directions. There's so much wisdom in the words you shared with us, I find it hard to summarize without merely restating exactly what you said. However, as the faculty's ethics officer, I'm not about to plagiarize you in front of this audience. So thank you, Judge, for your deeply thoughtful words. You've left us all with much to ruminate upon. You concluded your address by aspiring to emulate Margaret's ambition to, and I quote, work it out with intellectual rigour coupled with wisdom. You've once again demonstrated tonight how that can be done. Thank you. Finally, it seems apt to include in this vote of thanks Margaret herself. In the lead up to this event, I've been truly astonished by the number of people of different generations and different pathways for whom Margaret was special. A special teacher, a valued colleague, a role model, or just someone to have a really good debate with. My relationship with Margaret had a couple of facets, but the most prominent was when we both served as consultants to Herbert Smith Freehills. Not only were we both consultants, we shared a desk. And often we were in on the same day. I knew I wasn't going to be able to argue a right to the desk on the basis of legal eminence, so I decided to try the line that possession is 9/10 of the law. So I took to getting in earlier. Margaret, being a property lawyer, but also being a pragmatist, simply started getting in even earlier, which meant I had to start getting in even earlier still. It wasn't so much an arms race as a desk race. And I take from that a simple conclusion. You had to get up very early to best Margaret. In my case, about 5 a.m. But as Her Honour Justice Gordon reminded us, Margaret was always up for the challenge. And it seems to me the state and practice of Australian law is so much better for that. So it's now for me to invite the Dean of the Law Faculty of Law and Justice, he's looking at me, so to come back for some final comments.
I love surprises, but I don't wish to extend formal proceedings any longer than can be necessary, and what more can remain to be said. So thank you to my colleague Scott Donald, but thank you for his vote of thanks. But again, thank you to everybody for attending this event. It's been a really wonderful coming together, as Scott said, of the various parts which Margaret Stone embodied, you know, the academy, the profession, the judiciary, and presumably also people from elsewhere, from other walks of life, but who were attracted to the topic and the chance to pay tribute to a really remarkable Australian. Thank you to Her Honour Justice Gordon for her remarks tonight. Thank you to the Stone family and Herbert Smith Freehills, and to Chief Justice Bell for the use of the court. Thank you all for coming, and good night.